Hello friends. Today we are going to discuss about an important landmark judgment given by the Supreme Court of India. That is with regard to Advocate and Consumer Protection Act. In this video, I'll also be discussing about what are the implications with regard to medical profession because of this judgment. I'm Dr. Suresh Badadmat, Professor of Psychiatry, working at National Institute of Mental Health and Neurosciences, Bangalore. As I mentioned, in this video, I'll be focusing on the recent Supreme Court decision with regard to exclusion of advocates from the Consumer Protection Act. I'll be focusing on what are the arguments they placed before the Supreme Court and why the Supreme Court took this landmark judgment. What are the implications for the medical profession? And if we want to argue without becoming emotional, what are those important cognitive points we should keep in our mind will be discussed in this video. This important judgment, the case law is Bar of Indian Lawyers through its President Jasbir Singh Malik versus D.K. Gandhi, PS National Institute of Communicable Disease 2024. Let's look into the facts of this case. Mr. Kamal Sharma was supposed to give money to Mr. D.K. Gandhi, who is the PS of National Communicable Disease Institute. Mr. Kamal Sharma had issued a check of 20,000 rupees to Mr. D.K. Gandhi. Unfortunately, this check got bounced and Mr. Kamal Sharma refused to pay. Hence, Mr. D.K. Gandhi availed a service of a lawyer. In this check bounce case, under Section 138 of the Negotiable Instruments Act, as the check for 20,000 rupees issued by Kamal Sharma was bounced. A complaint was filed in the Court of Metropolitan Magistrate Tis Hazari, Court, Delhi. During this case, the accused, the Kamal Sharma, agreed to pay the amount. He issued a DD of 20,000 rupees and also check worth of 50,000 rupees, and he gave it to the lawyer of Mr. D.K. Gandhi. Unfortunately, the lawyer did not give this check and also DD to Gandhi. Instead, he demanded 5,000 rupees for his advocate fees. In this scenario, the Mr. Gandhi became very unhappy. He requested him to give back his money. But unfortunately, advocate said, please give me 5,000 rupees more in cash. Aggrieved by the demand of the advocate, Mr. Gandhi filed a case in the District Consumer Forum. He placed a request in front of the District Consumer Forum that lawyer needs to pay back his DD of 20,000 rupees plus 5,000 rupees, which was the check which the Sharma had given, along with this 10,000 rupees for the harassment and mental agony. Immediately, the advocate raised a preliminary objection on 3rd of March 1998, saying that advocates do not come under the Consumer Protection Act. Further, Mr. Advocate filed a suit for recovery of 5,000 rupees in the Court of Small Cause, Delhi, raising a plea that he needs to get his fees from Mr. D.K. Gandhi. At the same time, Mr. Advocate gave the DD of 20,000 rupees and also 5,000 rupees check. But at the same time, he requested Mr. Sharma not to honor the 5,000 rupees check. This is how the case goes. At the same time, the case at the Consumer Court continued. And let's summarize these facts. Mr. D.K. Gandhi, who is a PS of National Communicable Disease Center, was supposed to get money from Mr. Kamal Sharma. Mr. Kamal Sharma has issued a check of worth 20,000 rupees. Unfortunately, it bounced, and Mr. Kamal Sharma refused to pay. This was in 1998. Hence, Mr. Gandhi availed the services of Mr. Advocate, and a case was instituted in the court. Immediately, Kamal Sharma gave a DD of 20,000 rupees plus 5,000 rupees check was issued. Mr. Advocate took the both check and the DD and did not give it to DK Gandhi, but instead he demanded DK Gandhi to give 5,000 rupees cash. Aggrieved by all this scenario, DK Gandhi approached District Consumer Forum. As I mentioned, the advocate had raised a preliminary objection telling that advocates do not come under Consumer Protection Act. Here the District Forum clearly said that the advocates come under the ambit of Consumer Protection Act. This was the decision. Aggrieved by this decision, Mr. Advocate went to State Consumer Forum and appealed, telling that this was wrong. On 10th March 2006, the State Consumer Forum said the advocates do not come under the ambit of Consumer Protection Act, and the service of the lawyer or the advocates did not fall under the ambit of service as for the Consumer Protection Act of 1986. Here, the DK Gandhi became aggrieved, hence he approached National Consumer Forum in Delhi. And in National Consumer Forum clearly said that advocates come under the ambit of Consumer Protection Act and it is a contract for service. That was the decision given by the National Consumer Forum, and they said you need to pay the amount. Being aggrieved by the decision of National Consumer Forum, the advocate, along with the Bar of Indian Lawyers, Delhi High Court Bar Association, Bar Council of India, and others, appealed to the Supreme Court requesting that Consumer Protection Act should not be applicable to advocates or lawyers. Now, let's discuss how the argument is being placed. The Apex Court formulated 4 important questions. The first question was whether a complaint alleging deficiency in services against advocates practicing legal profession would be maintainable under the Consumer Protection Act. Second, whether the legislature ever intended to include the professional or professions or services rendered by the professional within the purview of Consumer Protection Act of 1986 or 2019. Fourth question was whether the legal profession is sui generis. That is it unique profession compared to others? Fourth one was whether a service hired or availed of an advocate could be said to be the services under the contract of personal services, so as to exclude it from the definition of service contained in the Section 2, subsection 42 of the CP Act 2019. These are the 4 questions which was raised by the Supreme Court. Let's take the first question. Whether a complaint alleging deficiency in services against an advocate's practicing legal profession would be maintainable under the Consumer Protection Act was the question. They went back to look into the history. The history of Consumer Protection Act across the world stemmed from the Secretary General United Nations, which submitted the draft guidelines to protect consumers across the world. This was placed by the Economic and Social Council of UNESCO in 1983. The main reason is taking into account the interest and the needs of the consumers in all countries, recognizing that consumers often face imbalance in economic terms, educational level, and bargaining power. And bearing in that in mind, that consumers should have the right to access to non-hazardous products, as well as the importance of promoting just, equitable, and sustainable economic and social development. When this convention was placed, India signed it, the Consumer Protection Resolution number 39 bar 248. Hence, India enacted Consumer Protection Act of 1986, which said that the emergence of global supply chains, rise in the international trade, and rapid development of e-commerce leading to new system for goods and services, new options and opportunities had become available to the consumers. Because of internet, because of e-commerce, there was a need for the amendment of Consumer Protection Act of 1986. Hence, the Consumer Protection of 2019 was amended and brought in. The main idea of the UNESCO was to help the consumer to get justice and a fair treatment in the matters of goods and services purchased and availed by them in a marketing dominated by large trading and manufacturing bodies. Indeed, the entire act revolves around the consumer and is designed to protect the interest of the consumer. The act provides for business to consumers disputes, not business to business disputes. That means it only protects the consumers, not the business to business disputes. There was not even a whisper in the statement of the object and reason either in the CP Act of 1986 or 2019 to include profession or the services provided by the profession, like advocates and doctors. Hence, this need to be removed was the argument. It was very well accepted proposition of the fact professionals or a profession could not be called as a business or a trade, nor the clients or the patient can be called as a consumer. This was the proposition placed by the advocates. The term business or trade have a commercial connotation, aspects, and could not be used interchangeably with the terms profession, which normally would involve some branch of learning or science. They had placed this argument. Hence, they said the profession cannot be considered under the Consumer Protection Act. Moving to the second point, whether the legislature have ever intended to include the profession or services rendered by the professionals within the purview of CP Act 1986 or CP Act of 2019. Let's understand what is profession. As per the 11th edition of Black Law Dictionary, profession means a vocation requiring advanced education and training, especially one of the three traditional professions, that is law, medicine, and the ministry. The ministry is basically the clergyman, the religious leader who provide spiritual services. Even the clergymen, these religious leaders do have their own ethics and they are rigorously trained. Professional means someone who belongs to a learned profession or whose occupation requires a high level of training and proficiency. In this matter, the Supreme Court also looked into Rupert Jackson and John Powell's definition of profession. They brought important 4 criteria. Based upon the nature of the work, which is a skilled and specialized, and a substantial part is mental rather than manual work. That means a professional needs to apply his mind to give the care or the services. Not only that, the professional also need to adhere to the commitment of moral principle which go beyond the general duty of honesty and a wider duty to the community, which may transcend the duty to a particular client or a patient. The third one is the professional association, which regulates the admission of that person into the profession and seeks to uphold the standards of the profession. by enacting certain professional code and conduct. Further, the last one is this professional should be a high status in the community, similar to doctors and advocates. The Supreme Court also made an observation from the IMA versus VP Shanta case. In the para 22, the Supreme Court at that time, the three bench judge clearly said, in the matter of professional liability, professions differ from other occupation for the reason that profession operates in a sphere where success cannot be achieved in every case, and very often success or failures depends upon factors beyond the professional man's control. In devising a rational approach to professional liability, which must provide a proper protection to the consumer while allowing for the factors mentioned above, the approach of the court is to require the professional man should possess a certain minimum degree of competence and that they should exercise a reasonable care in the discharge of their duties. In general, professional man owes to his client a duty in tort as well as in contract to exercise reasonable care in giving advice or performing services. This was the extract from VP Shanta versus IMA case. Further, profession means profession would require advanced education and training in some branch of learning or science. The nature of work is also skilled and specialized. One substantial part of which should be mental work rather than a physical work more. Achieving success would depend upon many factors beyond the professional control, which is not similar to the business, commerce, or trade. The fact that professionals are governed by their own respective counsel, like bar counsels in lawyers, medical counsels in doctor, would not absolve them for their civil or criminal liability. That means the advocates can be still pulled into civil court or criminal court. Similarly, doctors can also be pulled. Here, they placed an argument of requesting to remove the professional services from the ambit of Consumer Protection Act. If you look at the intent of the CPA, the person who drafted this legislation presumed to know the law, and there is no good reason to assume that the legislature intended to include the professions or the professional or the services provided by the professionals under the Consumer Protection Act. Any interpretation of the preamble or the schemes of the Act for construing profession as a business or a trade or a professional as a services provider would be extended beyond the scope of the Act. That means there was no intent by the draftsman of the law to include professional services or a profession under the Consumer Protection Act. The Supreme Court clearly mentioned in the para 21, of course, we are conscious of the decision in the Indian Medical Association versus VP Shanta case, in which three bench judge, this court has held inter alia that the wide amplitude of the definition of service in the main part of the section 212 subsection 1O would cover the services rendered by medical practitioner within the said section of the Consumer Protection Act. That means they have kept the decision of the VP Shanta. Further, they said that, however, in our humble opinion, the said decision deserves to be revisited, having regard to the history, object and purpose and the scheme of the Consumer Protection Act, and in the view of the opinion expressed by us herein above, to affect neither the profession could be treated as a business or a trade, nor the services provided by the professionals could be treated as a business or a trade. Hence, there is a need to remove the professional services from the Consumer Protection Act. The bench also said, this matter will be referred to the Chief Justice of India, and who will consider this and refer to the higher bench of judges. This was a landmark observation by the Supreme Court with regard to medical profession. That means all the doctors in the country have an opportunity to make an intelligent move not an emotional move. Of course, IMA versus VP Shanta case, we have lost almost 2 to 3 decades. There is no need to be emotional. At this point of time, we need to act cognitively. We need to take the points, how the advocates have argued their case. We need to go with the advocates and also appeal the Supreme Court so that the medical professionals can be removed from the Consumer Protection Act. Moving to the third important question, whether the legal profession is sui juris or is it different from other profession? This was an intelligent question drafted by the Supreme Court and answered. Sui juris means here whether the legal profession or the advocate, are they unique or they are the kind of only one profession which is different from other profession. The sui juris means it is not commercial in nature. The advocate's profession is a noble one. The independence of the bar and the autonomy of the bar council has been ensured statutory in order to preserve the very democracy itself and to ensure judiciary remains strong. They brought in the argument of constitution. They said it is unique because advocates play a crucial role in various aspects, from drafting of the constitution, protecting the constitution, and also they are the friends of the court. That means they are not the tradesman or a businessman. They are helping the court to deliver the justice. That means they are upholding the constitution. They assist in keeping the third pillar of the constitution, that is judiciary. Hence, it needs to be independent of any other limitations. Hence, they argued the role of advocate is indispensable in the justice delivery system. This is a very clever move done by the advocates. They also mentioned the bar or the advocate are the spokesperson of the judiciary because the judge does not speak. He gives only judgment. The opinion of the court or the speaker of the judiciary is advocates. Lawyer who brings the cause to the court are supposed to protect the rights of the individual of equality and freedom as constitutionally envisaged to ensure that the country is governed by the rule of law. That rule of law is to be enforced by the judiciary and helped by the advocates. Therefore, considering the role, status, and the duties of the advocate as a profession, professionals, apex court opined that legal profession is sui juris, that is unique in nature and cannot be compared with any other profession. That means, they said, it is unique even away from the medical profession. That means there is a doubt which has been casted that there is a possibility the medical profession may not be removed from the Consumer Protection Act. That's the reason they brought this sui juris in this judgment. The fourth question, whether a service hired or availed of an advocate could be said to be services under a contract of personal services or not. Now, we need to move to the fundamental understanding about contract of services versus contract for services. If you look at this, contract of service and contract for services. A contract of service means here a master and servant relationship. Here, the contract is already existed. For example, you are doctors. If you have a driver, you have a contract of service. That means you will decide and will control him where to go, how much speed to go, where to service the car, when to come, when to leave. That means a contract of service is an agreement binding on parties who are commonly referred as employer and employee. Here, the doctor is an employer and the driver is the employee. That is contract of service. What is contract for services? For means a generally If you are going to buy a flat, you may avail a services of a broker. That broker can be considered as a contract for service. Or else, if you are going to build a house, you are giving a contract of building the house. That is contract for services. Here, based on the agreement, the contract is made. A real estate agent or a broker who helps to sell the house or buy a house will be contract for services. Here, you cannot dictate him. You are a part of a person who is requesting a person to deliver service. Here, the whole essence of service versus for service, the degree of control and the autonomy plays a role. In contract of service, the control is complete, autonomy is very less. Whereas contract for service, control is minimal, autonomy is present. That means the whole decision to know whether an advocate or a doctor is like an employer-employee relationship, that is, patient is employing the doctor for this service, or else it is a contract for service. That is the question the Supreme Court has asked in this. Now let's discuss about contract of or for personal services. If you look at the Advocate Act of 1961, definition of advocate and legal practitioner was clearly said that whoever has passed the certain exams, qualification, they need to enroll and they are allowed to practice. Section 30, every advocate whose name is entered into the state roll is entitled to practice in the court of law. Further, the same act also says the disciplinary power for taking action against an advocate and impose punishment for their misconduct have been conferred upon the State Bar Council and the Bar Council of India, which is similar to State Medical Council and the National Medical Commission. In the light of this Advocate Act, we can consider the definition of services contained under the Section 2(1) of the CP Act of 1986 or Section 2, subsection 42 of the CP Act 2019 is same read as the services, and they are similar in both the legislation. What does it mean? Services means service of any description which is made available to the potential user and includes but not limited to the provision of facilities in connection with banking, financing, insurance, transport, processing, supply of electrical or other energy, telecom, boarding or lodging or both, housing, construction, entertainment, amusement, or perviewing of the news or other information, but does not include the rendering of any services free of charge or under a contract of personal services. That means this definition clearly excludes contract of personal services. That means if you look at the whole definition, it has three important points. The first point is service, what are they coming? That is, service of any description has been clearly made. And the second point is the provision of facilities in connection with specific services have been clearly maintained. And the final third one is if you provide service free of cost, they are excluded, and a contract of personal service will be excluded. That means if you have a driver who's driving your car, the driver cannot become under the personal services here. That means you cannot tell that you are the consumer and he is providing driving services. No, you are the employer and he is the employee. A contract for services as opposed to contract of services difficult to delineate at certain time, but the degree of control versus autonomy delineates clearly. There are various Supreme Court judgments in this regard. The correct method of approach, therefore, would be to consider whether, having regard to the nature of the work, there was a due control and supervision by the employer or not. Further, the Simon vs. Health Laundry Company clearly in this judgment, they clearly said the greater the amount of direct control exercised over the person rendering the services by the person of contracting for them, the stronger the grounds for holding it as a contract of service. That means if a person is availing services and he has a direct control over them, that is A. Suppose the greater is the degree of independence or autonomy of such control And the greater the probability of that services will be considered as contract for services. So if there is a control, then it becomes contract of services. If there is an autonomy given in the contract, that it becomes contract for services. In this, advocates, before they fight the case, the consumer or the client has to sign that is wakalatnama. Without signing that, the lawyer cannot take the case. Advocate can act for any person in any court when he is appointed by such person by executing a document called wakalatnama. Without wakalatnama, the consumer has not given the power to the lawyer. Not only that, once the wakalatnama is signed, now the advocate is also bound by the duties towards the court, duty towards the client, duty towards the opponent also, further, duty to the colleagues. And this has been enumerated in the Bar Council of India rules. One of the most basic principle of the lawyer is a client relationship is the advocate owes a fiduciary relationship. That means he has to act in the best interest of the client. The lawyer should follow the client's instruction rather than substitute their judgment for that of the client. A lawyer, by the virtue of retention, has the authority to choose the means for achieving the client's legal goal, while the client has the right to decide on what the goal will be. That is how beautifully they have argued their case. Moving to how this relationship of the client and the lawyer has been decoded. The relationship between the advocate and the client. Advocates are generally perceived to be their client's agent, and they owe fiduciary relationship. Advocates are fastened with all traditional duties that the agent owe to their principals. For example, advocate has to respect the client's autonomy to make decision at a minimum as to the objective of the representation. Advocates are not entitled to make any concessions or give any undertaking to the court without expressing the instruction from the client. It is the solemn duty of an advocate not to transgress the authority conferred to him by the client. An advocate is bound to seek appropriate instruction from the client or his authorized agent before taking any action or making any statement or concession which may directly or remotely affect the legal rights of the client. The advocate represents the client before the court and conducts proceedings on behalf of the client. He is only the link between the court and the client. Therefore, his responsibility is onerous. He is expected to follow the instruction of his client rather than substitute his judgment. Thus, a considerable amount of direct control is exercised by the client over the advocate. Advocate renders his services during the course of his employment to the client. And finally, the judgment was given. What did the judgment say? Answering all the 4 points, the Supreme Court said the very purpose and the object of CP Act, that is Consumer Protection Act of 1986, which is re-enacted by 2019, was to provide protection to the consumer from unfair trade practices and unethical business practices and the trade. The legislature never had an intent to include the profession or the profession services rendered by the professional within the purview of the Act of either 1986 or 2019. Further, they have kept certain amount of autonomy here. The legal profession is sui juris. That is, sui generis has been clearly said. That is, they are unique in nature with regard to their profession. They even, compared to the medical profession, they are said they are unique because they are protecting the Constitution of India and delivering the justice. That means there is a possibility the medical profession may not be moved out of the CP Act unless we are able to argue cognitively. The third one, the service hired or availed of an advocate is a services under a contract of personal service and therefore would not fall within the purview of Consumer Protection Act. And finally, a complaint alleging deficiency in services against an advocate practicing legal profession would not be maintainable under either Consumer Protection Act of 1986 or 2019. This is the judgment, ladies and gentlemen. Now, what are the implications of the medical profession? Let's discuss this because this is the crux of my today's presentation. We need to argue when we go to the Supreme Court. The professional standard and regulatory framework is similar to advocate. Medical professionals in India are regulated by Medical Council of India, currently the National Medical Commission. Hence, the main party who is going to plead also should be National Medical Commission and the State Medical Council across India. If we are united, we need to urge National Medical Commission and also the State Medical Councils to plead in front of the Supreme Court, asking to remove the medical profession from the Consumer Protection Act. This regulatory framework provides a robust mechanism for maintaining professional standards, addressing professional misconduct, and ensuring accountability through disciplinary powers conferred by National Medical Commission Act or State Medical Council. That means the patients can go not only to the civil court, to the criminal court, and also to this National Medical Commission or State Medical Council, telling that this doctor is erring, he is not doing his duty, he is unethical, misconduct, malpractice case. Complaint can be given. That means they have a redressal mechanism. Further, the patients can also give complaint under the Clinical Establishment Act. They can go to State Human Rights Commission, National Human Rights Commission, Civil Court, Criminal Court, and there are various quasi-judicial bodies have been formed under Medical Termination of Pregnancy, Transplantation of Human Organ Act, HIV Act, Mental Health Care Act, Right to Persons with Disability Act, ERT Act, Surrogacy Act, PNDT Act, and also Commission for Allied Healthcare Professional Act, Rehabilitation Council of India, Nursing Council of India. That means the patients have numerous mechanisms to complain against the medical profession. Now, we also have to discuss and argue the nature of the medical profession. We have to say that the healthcare is provision of care, not the services. All medical professionals, including the nursing, do not give service. Service is a commodity which is delivered. Here we give a care. A care is passionate, compassionate, empathy, and we provide care to the patient, irrespective whether we are losing the patient, we give care to the last breath. Hence, the medical profession is a noble profession dedicated to the service or the care of the humanity, requiring advanced education, training, and adherence to the high ethical standards. Medical professionals are required to exercise their professional judgment and expertise, often in a complex, uncertain circumstances, which distinguishes their services from other all professional services. Hence, it cannot be called as a services. It is a human care which is given. We also need to argue whether we are also sui generis nature. The services rendered by the medical practitioner are inherently different from any other profession. We are trying to uphold the important article of the Constitution, right to life and liberty. We protect the life. If the life is there, then only the sovereignty of the country comes into picture and the Constitution of India. That is how we need to argue. Hence, not only that, the medical practitioner also has to have a fiduciary relationship with the patient. That means they have to act in the best principle of the patient. It is not a typical consumer and a service provider relationship. Again, the Supreme Court has clearly said, Consumer Protection Act, the legislative intent was not to bring the professions or the professional services rendered under the Consumer Protection Act. Hence, there is no evidence to suggest the legislature or the draftsman of this Consumer Protection Act had any time intended to include profession. If you look at the Consumer Protection Act of 2019, they have deliberately removed the medical services and also the advocates. Now, we also need to argue, if it is continues to be included under the Consumer Protection Act, what are the fallouts? There will be a lot of frivolous, fraudulent cases, litigation, burdening the consumer dispute redressal mechanism, and whatever the professional services with regard to health is there, they will be running behind the courts and they will start defensive practice. Further, all these patients have various redressal mechanisms. Hence, they have avenues to go and give complaint. For that reason, we have to clearly say that including under the Consumer Protection Act increases the cost of healthcare. The studies across the globe clearly said that nearly 3/4 of the physicians report practicing defensive medicine, which is broadly defined as ordering of tests, procedures, excessive physician consultation, other medicals solely to reduce the risk of malpractice claims. One of the article which was published clearly said, the more you are defensive practice, the more you order the test, the lesser chances of malpractice case against you. That means if you are bringing the medical profession under the Consumer Protection Act, the defensive practice will increase to that level. 1/3 of the healthcare budget will be lost in defensive practice. Not only that, in US, $60 billion annually is lost in defensive practice. Is it the worth? Is it what we are looking for? Instead of providing the healthcare, instead of protecting the right to life, are we pushing them to fight in the court of law or in the consumer protection forum? This is not what we intended for 140 crore population. Further again, arguing for contract of or for services. The patients in the contemporary world, without informed consent, none of the doctor will operate or do any intervention. If you look at various judgments, Samira Kohli versus Dr. Prabhaman Chanda, it clearly says, even for diagnostic procedure, we need to take informed consent. Actually, they have said real consent. That means without the permission of the patient, you cannot do anything. That means the patient employs the doctor. Hence, it is contract of services. And the doctor's duty is to take permission from the client, explain him all the information, give alternatives, and based upon the patient choice, the doctor has to deliver his care. The medical professionals operate under a high degree of professional autonomy guided by ethical principle and professional standard that ensures the best interest of the patient. In this medical profession, success cannot be guaranteed. We need to argue moving away from service to provide care. We do not guarantee the cure. Every doctor guarantees the care. That means we need to move from services to care, cure from care. Here, the body heals on its own. The doctors provide the care. To conclude, my dear friends, we need to urge our professional body, like National Medical Commission and State Medical Council, to plead in the Supreme Court to protect our profession from the Consumer Protection Act. We need to hire excellent lawyers, academic lawyers from National Law School, Bangalore, and also the National Law School, Delhi, and other academics. We need to hire good medical legal experts to draft, and also the State Medical Council and other professional bodies like IMA. And we need to keep our emotions under control so that we argue cognitively and move out of the Consumer Protection Act in the larger interest of the society. Thank you very much for giving your valuable time.